Helping young people with fines. Hi, I'm Katrina and I'm a lawyer from Youthlaw, which is a community legal centre that helps young people up until the age of 25 in Victoria. In this session, we're going to talk about helping young people with fines. Fines can start off with infringement notices issued for a range of offences. This can include parking fines, failing to have a valid ticket on the train, or other minor traffic offences. If the fines go unpaid, they go through a variety of stages. The first stage, when a young person receives the infringement notice, the enforcement stage, where a fine remains unpaid and the fine gets sent to the infringements court, and the warrant stage, where the sheriff can take action and take you to court. At each different stage, we'll talk about a young person's options to deal with these fines, from seeking an internal review to what we call a special circumstances application. We'll also look at K-pins, which are for fines that were issued to a young person under the age of 18. As well as infringement notices, a young person can get a fine handed down by a judge or a magistrate at court for a criminal offence. We'll go through the options of how a young person can deal with these fines that are imposed by a court. As we proceed, I'll discuss some case studies and some frequently asked questions so you can see how this applies in real life. Please note that the names and details we use in these case studies are fictional. Please note that the information provided in this session is to be used as a general guide only. You should seek legal advice about your particular circumstance before acting on the information. This information is based on the laws of Victoria as of August 2012. Fines at the initial stage. To start with, let's look at an example of a young person who's just been issued with an infringement notice. Leonie, who's 20 years old, dropped into a youth housing service a few weeks ago to help find crisis accommodation. She became homeless because she was living with her boyfriend and he became violent. She had no choice but to leave and had nowhere else to go. She stayed in her car overnight and then drove up to the service the next morning for help. She had no money to pay for parking and she ended up getting a parking ticket while she was at the service seeking help. She's in crisis accommodation now, but she has no job, so she's worried about how she's going to pay for the fine. When someone gets an infringement notice, they have a number of options available to them. The first one is to pay for the fine in full before the due date. The second one is to ask for an extension of time or to ask for a time to pay plan. If you happen to have a Centrelink benefit, you can seek to have money automatically deducted from your Centrelink payments. This is known as CenterPay. The third option is you can ask for an internal review, and the fourth option is you can choose to go to court where you plead guilty or not guilty. It looks like Leonie will have some trouble paying for the fine in full or even by instalments. If she doesn't have a legal defence to explain why she had the parking ticket, then there's little point in choosing to go to court. Leonie does, however, have grounds to apply for what's called an internal review. In Victoria, you can apply to the agency to review their decision to issue you with a fine. So for Leonie, she could write to the council in the area where she got the parking fine to seek a review of the decision to issue her with that fine. If the council believes that she has sufficient grounds, they will withdraw the infringement notice. The grounds for getting a fine withdrawn based on an internal review are: 1. If it was unlawful for the agency to issue you the fine. 2. If there was a mistake of identity. 3. If the person was experiencing special circumstances. Or 4. There are exceptional circumstances relating to the infringement. There doesn't sound like there was anything unlawful about Leonie getting the parking ticket, and it also doesn't look like there's anything about mistaken identity. However, Leonie does have the option of applying for special circumstances. The law in Victoria says that if you experience special circumstances, then you can apply to have the fine withdrawn. What the law considers special circumstances are if the person experiences one of three things. The first one is if you're experiencing homelessness. So this includes if you're living in crisis accommodation, transitional housing, or if you're couch surfing. The second one, if you're experiencing mental health issues or an intellectual disability. The third one is if you're suffering a severe addiction to alcohol and other drug or volatile substances. If the young person had a drug or alcohol addiction or a mental or intellectual impairment, you must show that these circumstances led to the young person not understanding that the offence had occurred or that they were unable to control the conduct that led to the offence occurring. And if a young person was experiencing homelessness, they must show that due to their homelessness, they couldn't control the conduct leading to the offence occurring. For Leonie, it sounds like becoming homeless was a reason why she got her parking fine. Because of this, she could apply for an internal review based on the special circumstances of her being homeless. But Leonie would have to provide some evidence to the council to show that she was homeless at the time. This could be in the form of a support worker writing a letter establishing that she was homeless at the relevant date, and also showing that she could not control the conduct that led to the offence occurring. If Leonie were to apply for special circumstances on other grounds, such as the drug and alcohol addiction or the mental or intellectual impairment, she would need to get a support letter from a doctor or a psychologist. This letter needs to confirm the nature of her mental or intellectual impairment or her drug and alcohol addiction, and how this either led to her inability to understand that an offence had occurred, or that she was unable to control the conduct that led to the offence occurring. Some agencies may accept a support letter from a drug and alcohol counsellor, but it may not be accepted unless it's co-signed by a doctor or a psychologist. Leonie could also base her application on exceptional circumstances. Unlike special circumstances, there is nothing in Victorian law that defines what is considered exceptional circumstances. In Leonie's case, the fact that she has no income and that she has just experienced family violence could be considered grounds for which the council could withdraw the fine. Frequently asked questions. Can you make an internal review request for any kind of infringement notice? There are fines that you cannot seek an internal review for, and these are for drink driving, drug driving, or excessive speed of 25 kilometres an hour or more over the speed limit. However, if you weren't the driver at the time of the offence and you didn't receive the fine in person, so for example it was a speed camera offence, you can nominate another driver and the fine will be issued in their name instead. You can do this by filling out the nomination form, and usually this will be attached to the fine or at the back of the fine, and you just fill in the person's details, which will include their name and their driver's licence. You can also get a copy of the nomination form by contacting Civic Compliance. If you don't have all the necessary details to put down in that nomination form, you should seek legal advice by contacting Youthlaw or another legal service. The person you nominate does not need to know that they have been nominated as the driver, and you don't need their consent for them to be nominated. For excessive speeding fines, so that's when you've been speeding 25 kilometres an hour or more over the speed limit, you must put in your nomination form within 28 days of the infringement notice being issued. Where should you send an internal review request? There should be a name and address listed in the infringement notice or on the back of the notice saying where to send your request. For some fines, like police fines, Civic Compliance Victoria will be named on the notice as the place to send your request to. If in doubt, call the issuing agency directly or Civic Compliance to confirm where to send your request. Does Leonie need to write her own internal review request, or can somebody else do it for her? Leonie can write her own letter to request internal review with a support letter from you as her worker or someone else, but you can also write the internal review request in a letter on her behalf. If you are writing an internal review request letter on someone else's behalf, you should enclose a form signed by that person giving their consent. What happens once we've sent our internal review request to the agency? If the agency agrees that there are special or exceptional circumstances, they will withdraw the fine. If you apply for internal review on grounds of special circumstances and the agency rejects your application, the agency must then refer the matter to the Magistrates Court. If you apply on grounds of exceptional circumstances and the agency rejects your application, the agency may refer the matter to court, or they may give you a further time to pay. Even if they reject your internal review request, the agency can still waive some or all of the costs associated with the fine, for example if they issue a penalty reminder notice. You still have the option of asking for more time to pay or a payment plan. When is it too late to apply for an internal review? You can apply for an internal review of an infringement even if you get a penalty reminder notice up until the enforcement stage, which is the next stage we will be talking about.